Happy Monday, and welcome to another episode of Cases that should have gone to the Supreme Court of Canada, but didn't. Today we're talking about cabinet confidence. Cases that should have gone to the Supreme Court of Canada, but didn't. In Quebec, a group of specialized medical practitioners brought a constitutional challenge to certain legislation that impeded the work that they did, or that they viewed that impeded the work that they did, and improperly infringed upon their constitutional rights to do certain things in the course of their work as specialized medical practitioners. In advancing their constitutional challenge, the medical practitioners sought disclosure of certain information that would help advance their claims, and this is, of course, permitted in the constitutional challenge process. One of the things they sought disclosure of was cabinet memos related to the passing of legislation that affected them, and, in fact, the impugned legislation in that case. And the court ruled that because these were documents that were subject to special privilege as being cabinet documents, they were not disclosable even in the context of constitutional litigation, despite the fact that their claims actually hinged on what might be in these cabinet documents. And the arguments that they needed to make about the constitutionality of the scheme related to information that was contained within this cabinet confidence. And this raises important issues. If governments can hide important information about their views on the constitutionality of litigation, their knowledge of how litigation is going to affect or pursue as a result of decisions that they make to pass legislation, if it's going to impact on the constitutional rights of individuals and they know that and they discuss that in cabinet, can they hide that? Can they use that as a shield to guard against findings of unconstitutionality and to prevent individuals from obtaining the evidence necessary to prove that legislation is unconstitutional or invalid, to seek certain remedies for violations of constitutional rights? Allowing this unfettered privilege by covering everything in cabinet confidence is concerning. And yes, of course, there are circumstances where governments do need to do things and enact legislation and discuss potential legislation in confidence, but in all circumstances, does that need to be and remain in confidence, particularly where the legislation's been passed, it's now affecting individuals, and where they are challenging the validity of that legislation? If the government doesn't have anything to hide about the validity of its legislation, why is it claiming cabinet confidence over things that are really no longer needing to be kept confident as a result of the fact that they are, in fact, now public legislation? This is an important issue for the Supreme Court of Canada to consider because it impacts upon the ability to bring constitutional challenges to parties all across the country and the ability to challenge overreaching conduct on the part of the state. It's unfortunate that the Supreme Court of Canada didn't have the opportunity to consider this and to determine the extent to which cabinet privilege applies in the context of constitutional litigation. It's not going to open the floodgates to constitutional litigation just to find out what's in cabinet documents. There would still have to be some type of test that the Supreme Court of Canada could have created to allow this information to be disseminated, and it's unfortunate that they didn't. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases that should have gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.